Brittany Fortinberry, the Indiana teacher facing dozens of child sexual abuse charges, now has a bank suing her over unpaid credit card bills. But that is nothing compared to the bombshell allegations against both her and her husband, Nicholas Fortinberry, who's separately charged in this case. We're going to dig into her shocking criminal story, talk to former child sex crimes prosecutor Marian Braccia about bombshell legal questions. Can her husband be forced to testify against her? What happens to spousal privilege when the crimes involve children? Those answers may surprise you. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. By now, the name Brittany Fortinberry is very likely familiar to you, right? The former Indiana substitute teacher accused of sexually abusing minors while wearing masks from the Scream movies. Already facing a staggering 41 felony charges, Fortinberry is now dealing with another legal issue. A bank is suing her over thousands of dollars in unpaid credit card debt. According to court records that were obtained by Law&Crime, Synchrony Bank filed a lawsuit against Fortinberry claiming she failed to pay more than $2,000 in charges that were accrued since opening a credit card account in 2021. The bank alleges that Fortinberry defaulted on the payments and ignored repeated attempts to collect the debt. And given that Fortinberry has been behind bars since February, unable to post bond, her mounting financial troubles may not come as a surprise. But the civil case is so minor compared to the serious criminal allegations that she is facing. As we've previously reported, Fortinberry is accused of committing some of the most disturbing crimes imaginable for someone in a teaching role. Investigators say she sexually abused multiple underage students and encouraged them to participate in group sex acts, again, while wearing this horror-themed masks, including ones from the Scream franchise. And the case first came to light in August of 2024 when two students reported that Fortinberry had sent them explicit content over Snapchat, including nude images and videos involving sex toys. She resigned from her position at the time at Eminence Schools shortly afterward on August 23rd. But in November, she was formally charged with 2 counts of disseminating harmful material to minors and 2 counts of online harassment. But those charges were just the beginning, because by December, more alleged victims began to come forward. In one particularly alarming case, the grandmother of a 14-year-old boy told prosecutors that her grandson said Fortinberry gave him psychedelic mushrooms and performed sex acts with him. The teen also claimed there were more victims that were involved. And trust me, we have only scratched the surface of this, because we're going to get into just how more extensive the allegations against Brittany Fortinberry became. And one of the reasons that we can do this, to really dive into these cases, is because of the amazing support that we get from our sponsors like Upside. Now, Upside is great. It is a free app that gets you cash back when you buy daily essentials. So I pump my gas, I can use Upside. I go out to lunch, I can use Upside. Get something at a convenience store, I can use Upside. And why not get cash back when I do all these things, right? This is real cash back. It's money that appears in your Upside app that you transfer right into your bank account. So once you have the free Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app, you get paid. So to find out how much you can earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code SIDEBAR, because you'll get an extra 25 cents back on every gallon on your first tank of gas. Now, we got to talk about this latest legal headache, a civil lawsuit filed by Synchrony Bank. According to a complaint that was filed in Indiana's Morgan County Superior Court on July 23rd, the bank alleges that Fortinberry opened a charge account on November 19, 2021, and later defaulted by failing to make even the minimum of payments. An affidavit from a bank employee claims the last payment made on the account was on December 1st, 2023. So that's nearly a year before her arrest in the criminal case that followed. The affidavit goes on to state that as of July 8th, 2024, the account was officially charged off, meaning the bank had written off the debt as unlikely to be repaid. So what is Synchrony Bank suing her for? Well, in short, thousands of dollars, according to the filing. After receiving all payments, debits, credits, and set-offs, there is now due and owing from defendants to plaintiff the sum of $2,125.50. Due demand has been made on the defendants to pay this amount, and the defendants have failed to do so. By reason of the foregoing, plaintiff is entitled to judgment against defendants for breach of contract in the sum of $2,125.50 plus court costs. Wherefore, plaintiff requests judgment for breach of contract in the sum of $2,125.50 plus court costs. In other words, this is just one more legal problem adding to an already very long list. And yes, we'll get into how her criminal case ballooned to 41 charges. But first, I got to bring on a special guest and friend of the show, Marian Braccia, practice professor of law, director, LLM and trial advocacy program, and former child sex abuse, and also a former child abuse and sex crimes prosecutor. Thank you so much for coming on. It's great to see you.
Thanks, Jesse. Great to see you, as always.
Okay, so first question, does Fortinberry's pretrial detention, does that affect her ability to defend herself in a civil suit like the one from this bank?
Sort of. Obviously, she can't be physically present at any civil proceeding unless, of course, the plaintiff would request a bring down order, request a writ for her release to be present at the civil case. But really, the question is, if she's in custody and unable to pay her own bond, she becomes essentially judgment proof from the $2,000+ that are owing on her credit card debt. So this does seem like something of a more of an administrative proceeding to just have locked in for the records that this debt is owing, but I don't see realistically how it can be adjudicated or paid by the defendant, by Brittany Fortinberry.
By the way, isn't the cost of a lawsuit going to be more than what they're recovering?
It certainly could be, yes, just from the filing fees. And also, as you mentioned, the bank has already written this off as a loss. So again, I think it's just in an effort to go through the procedural steps to recover what is owed to the bank. But I don't think realistically it is real high on Fortinberry's priority list.
Yeah. And by the way, if she's ultimately convicted and sentenced of the crimes that she's facing, how does criminal restitution and civil penalties, how is that prioritized, especially when, financial recovery is quite limited?
Right. So it really depends by state, and the Victim Compensation Fund by state would dictate how certain court costs and payments are allotted and where they are credited, to what count they are credited first. So it would really depend. I would venture in Indiana, and admittedly, I'm no expert on Indiana restitution law, but I would venture that the victim compensation or the criminal restitution would take priority if there is in fact criminal restitution ordered, and then it's possible that the civil claim would go to third-party collections and might just go into her longstanding debt as a private citizen.
I assumed you were an expert on every kind of law. This is what I didn't realize. That's what I've always assumed. I think we all assume that. Yeah. This feels like a stretch, but I was wondering it. If this civil suit, these allegations, could that any way be used in her criminal case? Could it help the prosecution indirectly? I'm not sure. By uncovering spending habits or communications, does it corroborate grooming behaviors, the timeline of abuse? I guess if funds were used maybe to facilitate this alleged abuse, right? That could be a way.
I think maybe. I think the name of the game for any litigation strategy is creativity and persuasive storytelling. There are certainly rules of evidence, and that's my favorite topic, but there are certainly rules of evidence that allow for other acts to be shown or be admitted for the consideration of the fact finder, so that it can complete the telling of the story or the allegations that the moving party, or in this case the prosecution, is bringing. I tend to think it sounds a little attenuated. It sounds a little disparate and distinct from the facts that are alleged in the sex crimes case. But again, if there is some connection to how the defendant was using her bank or the funds from that credit card account in order to facilitate the abuse that she allegedly perpetrated, perhaps there is some connection there, but I think that would likely be a motion that the prosecution would have to bring pre-trial to allow the trial judge to consider it and consider the admissibility of that evidence before they ever even open to a jury.
By the way, talking because you love evidence so much, and we're going to get into this, this case, do you feel is going to be a lot about establishing a pattern? Is it going to be establishing a motive, an MO? I mean, do you think that the amount of evidence that's going to be permitted in this kind of case will be substantial for the prosecution?
So I think, as we've talked in other cases where there are multiple complainants or multiple alleged victims, I think that it could go either way. And a caution for the prosecution would be that perhaps these complainants, these alleged victims, know each other. Perhaps they're classmates, perhaps they're schoolmates, perhaps they have quote unquote compared stories. Perhaps those conversations have influenced the versions or the accounts of the abuse or the interactions that each alleged victim has reported to police. So those are all defense considerations to say, how similar are these accounts, and are they similar enough where it has the ring of perhaps fabrication? And I'm not saying that the complainants should not be believed and that they shouldn't be granted an open mind of any fact finder to listen to their testimony. But I think that is the cautionary tale for any prosecutor in a case like this is to make sure that each account has the ring of truth and doesn't seem like it's been affected or influenced by the other accounts that are being reported simultaneously. I think, however, a strength for the prosecution case is that there is numerosity. There are so many different complainants reporting very similar conduct, similar contact with this defendant, even when the other alleged victims weren't present or weren't even known to the others. And so that is, I think, a strength. Long story short, it could go either way, but it really depends on how the evidence is presented by the attorney.
Now let's talk about that. I want to revisit some of the disturbing allegations, I should say, because if the original allegations against Brittany Fortinberry were alarming, I will tell you what followed was even worse. The former Indiana substitute teacher was first thrust into the spotlight in November of 2024, and that is when two students came forward with allegations of inappropriate contact. As the investigation deepened, so did the severity of the accusations. Prosecutors have since filed dozens of additional felony charges, including incest, painting an increasingly horrifying picture of Fortinberry's alleged conduct, and we have reviewed all of the available probable cause affidavits. While some details are just way too graphic to share in full, the emerging narrative reveals a deeply disturbing alleged pattern of predatory behavior and calculated exploitation of minors, all while Fortinberry was entrusted with a position of authority. And her initial charges, 2 counts of disseminating matter harmful to minors, 2 counts of electronic harassment, they stem from claims that she sent explicit photos and videos to underage boys via Snapchat and Instagram. According to the complaints, some of that content included nude selfies, footage involving sex toys, and videos filmed inside her home, which allegedly featured a stripper pole. But the case quickly spiraled far beyond those initial charges. Why? Because as more alleged victims stepped forward, court documents revealed increasingly grotesque claims. Multiple minors accused Fortinberry of engaging in sex acts with them, sometimes during these group encounters. As I mentioned, wearing masks, the Scream franchise. Now, to understand the scope of these accusations, it is important to revisit how this all began, because according to a police report from November 2024, one teenage boy said that Fortinberry initially followed him on Instagram, started with casual, seemingly innocent messages. Situation quickly escalated. That police report reads, quote, alleged minor victim said that she was showing him a picture of something and thought it was her home gym. Alleged minor victim said that she then sits her phone down, making it a point so he could see it, and her photo gallery was open with photos of her completely naked. On another occasion, alleged minor victim said that she sent him a picture of her room, and in the picture was a stripper pole. Alleged minor victim talked about her telling him that after she left Martinsville that she was a stripper, how she had an OnlyFans page, and did exclusive stuff on her Snapchat stories. By December, the case took an even darker turn. A grandmother contacted authorities, reporting that her 14-year-old grandson was involved in an inappropriate relationship with Fortinberry. And the boy told investigators that he feared Fortinberry would continue to abuse more children if she wasn't stopped. A police report from February reads, alleged victim said he's there because he doesn't want Brittany Fortinberry to molest more kids. Alleged victim said that some of the victims are considering talking about what happened, and there's others that don't want to talk about it. Now, as detectives followed up on his claims, a wave of new disclosures followed. Ultimately, 5 more minors came forward, each with their own harrowing account of alleged abuse, including claims that Fortinberry would masturbate to students' school portraits, give the teens psychedelic mushrooms before sexual encounters, and maybe the most disturbing account involved a night in which Fortinberry allegedly took a teenage boy shopping, spent more than $600 on clothes, and then invited him and his friends back to her home, and there, the victim claimed she eventually turned on a movie and proposed a group sex act on one condition. According to an affidavit from March, it reads, alleged victim said that Brittany turned on a movie, and about 30 minutes into the movie, Brittany asked one of his friends if they wanted to gangbang her. Alleged victim said that Brittany had one condition for them to have the gangbang with her, and that was that they had to wear a scream mask. But the allegations didn't end with Brittany Fortinberry, because court documents suggest her husband, Nicholas Fortinberry, may have known about the abuse, and in some cases, allegedly threatened victims to keep them quiet. The March affidavit reads, alleged victim said Brittany told him that if anyone found out that Nick would slaughter him in front of his family. Nicholas Fortinberry filed for divorce, by the way, on February 25th. It raises questions about whether the criminal investigation influenced that decision, but shortly after, March 6th, he too was arrested and charged with intimidation and failure to report a crime. Now, Professor, with Nicholas Fortinberry now charged separately, but potentially possessing knowledge of the abuse, how should we be thinking about spousal privilege? The rules kind of complicate the case against Brittany, right?
Right. So there is a difference between spousal privilege and marital communication. So spousal privilege means that as a married person, I can, if I have been subpoenaed to testify, God forbid, against my husband, against my spouse, that privilege belongs to me as the witness to say, no, I choose not to testify against my husband or my spouse. However, if I said, you know what, I feel perfectly comfortable testifying against my husband, that would be my prerogative. That would be within my purview to either accept the subpoena and present myself to testify, or to absent myself and assert my privilege and say, no, I'm not testifying against my spouse. However, even if I did present myself and testify against my spouse, what is protected and what the defense can assert and prevent the fact finder from hearing are communications that occurred within the marriage that would be considered confidential, that would just be, those intimate conversations that occur between partners, between spouses. Now, there are exceptions that apply when there is intrafamilial violence or intrafamilial alleged crimes that are committed, and also when there are alleged jointly committed crimes. So the fact that there is an argument that Nicholas Fortinberry was working in concert with Brittany to intimidate her still alleged victims is an argument that these two were working in concert, that there were jointly accomplished crimes, and that an exception should apply that would essentially enable the fact finder to hear those confidential communications that may have transpired between the spouses while they were still married.
What do you make of what he's facing right now? It's a very bizarre allegation, disturbing to say the least, and it does make you wonder how his testimony could potentially be used against Brittany. Could there be leverage against him? Could a deal be worked out? But just what he's facing and the allegations are very interesting.
They are. Indiana is a mandatory reporter state, so anybody, not just a teacher, not just a social worker, not just a medical professional, anybody in Indiana who has knowledge of child abuse occurring has a requirement, is required by law to report that. And so the allegation is that Nicholas Fortinberry was aware of the abuse that was, again, allegedly being perpetrated by his wife against these minor boys. And so it was his duty, his mandatory requirement under Indiana law to report his own wife. And then, of course, couple that with the fact that there's an allegation that he threatened harm to the victims if they reported it or turned Brittany in, and then that, of course, escalates the charge to intimidation, which is a very serious felony and could carry some significant term of imprisonment.
Unfortunately, this case is going to rely heavily on the minor victim's testimony. I think we have to expect that. What are the special considerations that you should be thinking about, we should be thinking about, would you advise when you prepare child witnesses for cases involving disgusting and graphic allegations?
Right. So Again, under the rules of evidence, the trial judge runs the courtroom and runs the conduct of the courtroom and how witnesses are examined, the order in which witnesses are examined, what questions are permitted, and even what accommodations are permitted to make witnesses more comfortable. So a perfect example of that is with some child witnesses, perhaps a little younger than the witnesses we're talking about in this case. Sometimes they have a support person there or a victim advocate. Sometimes they even have a support teddy bear or toy that will make them more comfortable. Sometimes they'll even have a support dog or a pet, again, that makes them feel safe and secure when they're on the witness stand. Now, there's been lots of litigation about whether that is prejudicial for a jury or for a fact finder to see. Does it make the victim more sympathetic to be clutching a teddy bear or stroking a dog, a sympathetic pet while they're on the stand? But that is entirely up to the judge to decide the conduct of the courtroom and how these witnesses are presented. I think with any case involving vulnerable witnesses like children, there should be consideration of how often they are prepped, how many times they're asked to repeat their account of what happened to them. Are we, vis-a-vis that prep process, reinforcing the trauma that they may have lived through? Again, will there be an allegation that their testimony has been rehearsed or choreographed because of how many times they've been prepped? But there is also an argument that in order to make these witnesses more comfortable and answer questions more fully and more candidly, that they should be exposed to the environment. They should see the courtroom ahead of time, see the witness stand ahead of time, and there may also be motions by the prosecution to close certain portions of the proceeding so that they're not public, so that members of the public can't come and sit in the gallery and see the identity of these victims, hear their testimony, and make it a little bit more of a closed, private, intimate proceeding. Of course, that flies in the face of the defense's constitutional right to confront their accusers and to have a public trial. But again, that is entirely within the decision-making of the trial judge and should be worked out pre-trial.
A little bit more about Nicholas Fortinberry for a second. So during a March 6 court hearing in sworn testimony, an investigating officer revealed that one of the alleged victims, identified as victim number 2, disclosed a terrifying alleged encounter involving Nicholas. According to the officer, victim number 2 disclosed that he was with Brittany and another unknown child when they went grocery shopping. Upon returning home, Nicholas arrived from work, had a private conversation with Brittany, then confronted the victim directly. Nicholas allegedly told the 13-year-old, "If you don't stop what you're doing with my wife, I'm going to kill you in front of your family." He added, "Do not continue to do what you're doing with my wife until you turn 16. Now, the testimony suggests that Nicholas Fortinberry was not only aware of his wife's alleged sexual abuse of minors, but took this active, threatening role in attempting to manage or conceal it. And to provide context, this is the same victim that we mentioned previously who told police that Brittany Fortinberry had groomed him with expensive gifts and coerced him and his friends into group sex acts while wearing the Scream mask. Professor, based on this testimony where Nicholas allegedly threatened a victim while acknowledging the sexual relationship, are there charges beyond what he's currently facing?
Well, I think the argument for the defense is that there was intimidation there, but not intimidation directed toward being a witness or a victim, not intimidation to not report. If anything, there was intimidation to cease the sexual encounters. And so while a little bit of a twisted defense, perhaps, I think it is an available defense. Beyond that, we'd have to look at the Indiana statutes to see if there are statutes covering what are known in Pennsylvania as terroristic threats, or alleging an act of violence, either verbally or non-verbally, directly or indirectly, that may perhaps supplant the intimidation charge if all of the elements of intimidation of a witness are not present in this particular instance.
So you go back to Brittany Fortinberry. By May 22nd, the charges against her had ballooned to 41 counts, okay? Child molestation, sexual conduct with minors, incest, after court filings revealed deeply disturbing new allegations involving her own young child. Probable cause affidavit dated May 19th, authored by Detective Patrick Williams, details an interview between Fortinberry's then 7-year-old son and a forensic interviewer identified as Anna, and what the child disclosed was heartbreaking and horrifying. That affidavit reads, he tells Anna that his dad wanted him to talk with the detective again because his mom had sex with him. I would advise that he spelled sex out for Anna. He said he didn't know it was bad or anything because he was 7 years old and going into the 2nd grade. According to the child, Fortinberry joined him in the shower, sexually assaulted him. The abuse, he said, continued afterward. After the incident, she allegedly gave him pizza rolls, instructed him to keep it all a secret, and even more chilling, I want you to listen to this part, he then said Brittany told him she was going to do it again when he was 13. Professor, does it get any worse than this?
I don't think it ever. I don't think we will ever be able to wrap our brains around a scenario where a child is hurt. So does it get worse than this? Unfortunately, with the depths of our potential for hurting other humans, unfortunately, I don't know if it gets worse than that, but it is pretty bad from what we're hearing at this point.
According to the court records, this is the breakdown of what Brittany Fortinberry is facing. 15 counts of child molestation, 1 count of incest, 11 counts of sexual misconduct with a minor, 5 counts of contributing to delinquency of a minor, 6 counts of disseminating harmful material, 3 counts of performing before a minor. Professor, before we wrap things up, how does she defend herself against this? I mean, yes, these are allegations. Yes, she's innocent until proven guilty. It seems like an uphill battle if you ask me.
I hear you, and it does look like that from, again, the voluminous amount of reports and allegations and the number of witnesses that there are, the number of alleged victims that there are. I think if I were on the defense team, the number one thing that I would seek to do is sever these cases, meaning that I would want the incest charge to be heard separately from the other victims' charges. I would perhaps want the other victims all divvied out and dealt with at individual proceedings. Again, that numerosity can work in either direction, but when it comes to the incest charge, if I were on the defense team, what I'd be wary about is a juror or an independent fact finder hearing about even an alleged incest charge, and my reaction or my instinct as a fact finder would be, well, if you could do that to your own blood, if you could do that to your own child, why wouldn't you be able to abuse children who were not yours, children who you had no relation to, in much the same or even a more violent and graphic way. So again, if I were the defense team, I would focus a lot on the pre-trial aspect of this and being able to separate out the individual cases, because when they are lumped together, from a prosecution perspective, there might be strength in numbers.
It's a good point, and that's maybe what we'll see happen. Brittany Fortinberry remains in custody at the Morgan County Jail on a $150,000 bond as prosecutors pursue these multiple charges against her. And according to court records, she is scheduled to be back in court on August 14th for a pretrial conference. Professor Marian Braccia, thank you so much for taking the time. Awesome analysis as always. Really appreciate it.
Thanks, Jesse. Great to see you. And
that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.